McKinney 911. What is the address to your emergency?
All right, hey, welcome everybody. I'm going to do a video here. I wanted to kind of get you all pumped up a little bit before I started this, so please forgive the 3-minute long intro to this video. I think those of you that are watching, hopefully, if you didn't want to pay attention to that, if you're watching this after the fact, can just skip through all that. This video, if you may have heard by now, the Supreme Court today released the decision in the New York State rifle Bruen case. This is the case, just to give you some background. So New York has a law that requires a citizen to display what's called good cause, or to show good cause in order to be able to qualify for a license to carry a firearm concealed in public. And as you know, most law enforcement officers deny that request in the state of New York. So you've got two individuals that decided that they'd had enough and they were going to challenge this in court. Their names of Mr. Koch and Mr. Nash, although the case isn't named after them because the New York State Rifle and Pistol Association is the main plaintiff along with these two individuals. And I wanted to quickly tell you, so if you know, if you don't want to listen to all of this, let me know, because the decision, which I've read, okay, this is the entire decision. It's about 130 pages. Yes, I should be studying for the bar exam, but I, you know, isn't reading a Supreme Court case and understanding constitutional law part of the the study process for the bar? I think so. And I couldn't help myself. I wanted to read this thing as soon as it was released. So if you don't want to go through this whole video, here's the bottom line. The Supreme Court in Heller, if you remember, recognized what the rest of us already know, that there's a right to defend yourself in the home and that a state cannot prevent you from carrying a firearm in the home. What Heller did not decide, and what McDonald did not decide, although McDonald was just a states' rights issue that applied the 14th Amendment, what Heller did not decide is whether you have a right to carry that firearm in the public. So bottom line, What the Supreme Court just said is you have a right to defend yourself with a firearm in public. There you go. You don't have to watch the rest of this if you don't want to. That's something that we already knew, but apparently there are certain morons on the left that needed someone to tell them what normal people that have at least two brain cells to rub together already knew, and that is that we have a right to self-defense and a right to defend ourselves in the public. So there's the bottom line up front. Now we're going to do what we're going to do is quickly go into all of this. I am not going to go into the I have read the dissents in this case. This was a 6-3 decision. You can guess who the three were that did not sign on to this at all. But yeah, so here's the so New York has a law. Not anymore. It's now unconstitutional. So I don't know what they're going to do. As of today, it's unconstitutional. It's always been unconstitutional, but you know the oligarchs in the black robes have finally made it clear that it's unconstitutional. They had a law that makes it a crime to possess a firearm without a license in the state. Okay, a lot of states have that, and that includes the law. Also, it includes that you have to get that license if you want a firearm in your house and if you want to carry a firearm out in public. Now, you could get a what's called a an unrestricted license. I think they called it. Yeah, an unrestricted license, which allows you. So you need a regular license, which is generally since Heller has generally been approved to carry and have a firearm in the home. And I'm going to tell you guys in the chat. I do see the chat moving. I'm glad y'all are here. I appreciate everybody being here. If you have specific questions, save them, hold them. I will try to answer a few of those at the end, but I'm not going to see them until I'm done. Otherwise, I'm just going to get distracted, and this is going to take forever. So the licenses to be able to carry a firearm and own a firearm in the home were generally, although you shouldn't need a license in the home to begin with, you shouldn't need a license at all. The license itself is an unconstitutional infringement. You know, when you have to beg government for permission to defend yourself from government, I think it's obvious where that's eventually going to lead, but I digress. So you could get a regular license, but to get an unrestricted license, you had to get an unrestricted license in order to carry out into the public. And in order to get that license, you had to display what's called proper cause. And this is what the law itself says. You must be able to, quote, demonstrate a special need for self-protection that's distinguishable from that of the general community. So in other words, there has to be a particularized, according to New York, you have to have a particularized reason that your life is in danger, not just the fact that New York is a dangerous place. In other words, you have to prove that somebody that you've never met is going to target you and try to steal your wallet before they try to do so. And because of this generalized interest in self-defense, the plaintiffs here are Brandon Koch and Robert Nash, and the New York State Rifle and Pistol Association helped them fight this case. But they were both denied their licenses for an unrestricted license because they failed to show proper cause. Now, what they, of course, said is that, well, I don't need to show proper cause. The Second and 14th Amendments, well, the Second Amendment says shall not be infringed. I have a right to self-defense. Oh, and by the way, the 14th Amendment says you New York, you can't prevent me from having that right. And that's what they argue this whole time. Now, here's what's interesting. The district court didn't even want to hear the arguments. They just dismissed the case. So this issue was never even necessarily litigated. It was based off of a Second Circuit decision, and therefore, when they filed their case to say, "Hey, I want to challenge this law as unconstitutional," the court didn't even allow a hearing. It just outright dismissed it. And then, of course, the appellate court did the exact same thing. The Court of Appeals, they affirmed this ability to just dismiss the case. Now, this is probably a good thing because you know what's going to happen. You're going to argue it in New York. It's a tyrannical state. and you're going to lose anyway. So at least I guess this was a little more streamlined, even though this was a few years coming, that it went this way, that they just outright dismissed it. But they don't want to hear the facts. The courts in New York didn't want to hear the facts. They wanted their tyrannical government to continue. They wanted their people to be defenseless, and they wanted no one to be able to stand up in the case of even more tyranny. So what the New York tried to say was that, hey, look, their proper cause standard is fine because, we showed that this law is substantially related to the achievement of this important governmental interest. Now, what is this important governmental interest? It's oddly enough, they never really talk about that, that their citizens just get slaughtered and they can't defend themselves. I'm not sure exactly what their important governmental interest is. They say the public safety, but guns ensure the public safety. Now, quick side note, one of the things I've noticed as I was preparing for this is it makes me so happy that people like David Mediahog of March for Our Lives and many of the others are absolutely incredulous about this whole thing. They are upset about this, and of course they're yelling and screaming about history and all that kind of stuff. And I'm going to get into a little bit of the history because obviously when you're dealing with a constitutional right, you have to invoke history. The left loves to say, oh, we didn't have these kinds of guns, and oh, it only protects muskets and all that kind of stuff. Well, thankfully the court sort of quashed this, but the libtards aren't going to shut up about it. The gun grabbers are still going to continue. So the court held, here's the actual holding in one line. New York's proper cause requirement violates the 14th Amendment by preventing law-abiding citizens with ordinary self-defense needs. Ordinary self-defense needs. Ordinary. We all have a right to self-defense. It is that is a right that is ingrained into the Second Amendment. It's in our Declaration of Independence, an inalienable right to life. And because you have that inalienable right to life, you have an inalienable right to defend that life. So the law that prevented ordinary citizens from ordinary self-defense needs from exercising their Second Amendment rights, keeping bear arms for public defense. So it violates it. All right. Now, the court held, I've already talked about that. Since Heller and McDonald have been released, a lot of these lower courts, these appellate courts, they've created a sort of a two-step framework. And the court talks about this two-step framework in order to determine whether or not a particular law or regulation violates the Second Amendment. And the first thing is, Heller talked about looking to history. I understand the intent behind this. I'm not quite sure I support that as an argument, but that's the argument now judicially that we have to have because the courts have said so. So jurisprudence now is that they didn't create a strict scrutiny standard for the Second Amendment like they have for other rights, which is odd because in the same opinion, both Heller and the current opinion, they talk about the fact that the Second Amendment is not a second-rate or second-class right. Yet they still, to this day, even in this document, refuse to acknowledge that any law that is written in violation of the Second Amendment must be analyzed under a strict scrutiny framework, just like the First Amendment that they do, and the Fourth Amendment. So it's interesting that the two-step framework combines history with means and scrutiny. That's what a lot of the appellate courts is. The court, thankfully, in this case, rejected this two-step framework. But I don't like the reason that they did that because the framework they've used combined history and a means-end scrutiny. So this is a whole new type of scrutiny. You've got strict scrutiny, intermediate scrutiny, and now and you've also got this means-end scrutiny that I've never heard of. I mean, we never studied means-end scrutiny in law school. But that's probably because it's not something the Supreme Court has ever endorsed, but that's what a lot of the courts at the appellate level have been endorsing. Well, the court rejected that means in scrutiny test, part of the two-pronged test, but it endorsed still this history, this like historical context thing. And the reason that, it might work for us today, and it did work for us today, is because what if, this globe that we're sitting on is still around in 1,000 years, right? What if that history in 1,000 years from now, they're looking at and that's of course assuming that we haven't destroyed the left hasn't destroyed this country and its constitution, and the people haven't cowardly given it up. What if history changes in the future, and you've got several hundred years of history of infringement? Now, I say that only because I'm trying to look at all the different arguments here. Thankfully, we should not be able to have that kind of history because we've got these decisions now, the Heller case, the McDonald case, now the New York State and Rifle, I guess the Bruen case is probably what it'll end up being called. I'm not sure. Yeah, it'll probably be called the Bruen case, I think, in the future. So we've now got the Bruen case, and hopefully this creates a history that is more friendly to the Second Amendment as opposed to not. But when a court says that we're going to look to history, that scares me a little bit because history can change. Our future can be someone else's history, and that future might not look so good. But yet, if future courts are going to look at history, you see where I'm going. Okay, I'm not going to belabor this. Here's what I like. This is a very important statement that the court mentioned that we're going to be using in cases to come, okay? The Second Amendment is, quote, the very product of an interesting balancing by the people, and it, quote, surely elevates above all other interests the right of law-abiding, responsible citizens to use arms for self-defense. It goes on later. Here's a part here. The individual self-defense, because individual self-defense is the, quote, central component of the Second Amendment. I mean, that's an important statement, that individual self-defense, a central component. Actually says the central component, not a central component. The court says it's the central component of the Second Amendment, okay? Later, here's the funny thing is, let me go back a little bit. New York tried to say, because remember in Heller it talked about, the court said that, this doesn't affect being able to regulate guns in, quote, sensitive areas. What New York tried to argue in defending this case was that New York was a sensitive area because it's a very highly populated area. There are a lot of people, and that makes it a very sensitive area because the likelihood of something bad happening is particularized in places where there are a lot of people. Well, the court said malarkey. New York's attempt to characterize its proper cause requirement as a sensitive place law. So they tried to say that this law, oh no, this isn't an infringement. No. This complies with Heller. And because it's a sensitive, this is a sensitive place law. We created this law not as an infringement, but in order to comply with Heller so that, and we have deemed New York to be a sensitive place. Well, the court says that lacks merit because there's no historical basis for New York to effectively declare the island of Manhattan a, quote, sensitive place simply because it's crowded and protected generally by the New York Police Department. Let me ask you something. Do you think New Yorkers feel generally protected by the New York Police Department? I don't think so. And then here's the kicker right here. The plain text of the Second Amendment protects Koch's and Nash's proposed course of conduct, which is carrying handguns publicly for self-defense. Let me take out the extraneous words here. The plain text of the Second Amendment protects carrying handguns publicly for self-defense. It's highlighted right there. I even put little stars next to it. That's the part that you are going to be. That's the part that you is going to be quoted for years to come. I will say it one more time because it's glorious and beautiful. The plain text of the Second Amendment protects carrying handguns publicly for self-defense. Nothing in the Second Amendment's text draws a home public distinction. So what the court here is doing is it's broadening Heller to encompass not just the home, but also public self-defense. Nothing in the Second Amendment text draws a home public distinction or a home public distinction with respect to the right to keep and bear arms. And the definition of bear, this is what I've been arguing for years. Everyone wants to talk about keeping arms, but no one ever argues, hey, what about bear? I mean, we have a right to bear arms, not just have guns. The leftists talk about we have a right to have guns. No, we have a right to bear arms as well. We have a right to bear arms. We have a right to keep arms. What does bear mean? It means to take on the weight of something. Okay, to take on well, the weight of something. I'm not even going to go any further than that. I'll just finish the sentence again. Nothing in the Second Amendment's text draws a home public distinction with respect to the right to keep and bear arms. And the definition of bear naturally encompasses public carry. Moreover, the Second Amendment guarantees an individual right to possess and carry weapons in case of confrontation, and confrontation can surely take place outside the home. You would think that's common sense. The left is always talking about common sense gun regulation. Isn't it common sense that the place people get attacked is on the streets, in the subways? All right. So there's that. What else did I want to highlight here? You know, here's what's funny. And this is another thing I'm glad the court addressed, because you hear this a lot when you are when you're dealing with the left and debates and things of that nature. And they talk about, oh, you know, we've always cities have historically been able to ban guns. I mean, look at Dodge City, you know, way back in the day and all that. The court addressed that because that's one of the things that New York, look, there's a history of this. There's a history of cities being able to ban guns within the city limits. Well, the court saw through that nonsense. We've seen through that nonsense for years, but the court saw through this nonsense as well. So they identified. Here's the funny thing: and I'm just going to read this. Respondents next direct the court to the history of the colonies and the early republic, but they identify only 3 restrictions on public carry at that time. What are those 3 restrictions? Dodge City was one of them. In Arizona, anyway, you know the 3 cities they're always talking about. The 3 out of how many that are out there? Anyway, but they only identify 3 restrictions, and this is what I love, because finally the court is I don't expect the left to read this stuff. They're not going to read this, so they're not going to understand it. They're not going to learn history. They're going to continue going with the same old picture. You know, it's based off of an old picture of Tombstone. There you go. Thanks, John. Yeah. Of an old picture that I've been to Tombstone so many times. I can't believe I forgot that. You know, of a sign that said, you know, no guns in town or whatever. So while the court doubts that just 3 colonial regulations should suffice to show a tradition of public carry regulation, even looking at these laws in their own terms, the court is not convinced that they regulated public carry the way that New York was. So here's what the court says. The statutes essentially prohibited bearing arms in a way that spread fear or terror among the people, including the carrying of, quote, dangerous and unusual weapons. Whatever the likelihood that handguns were considered deadly or dangerous and unusual during the colonial period, they are today the quintessential self-defense handgun. So, and here's the other thing, and it talks about this later. Let me see if I can find, I know I highlighted this. I don't even need to read it. I can just tell you. These regulations that existed, they existed in territories of the United States. Territories. As you know, territories were a very, time frame wise, a very short period of time. And once these territories became states, these went away. A lot of these went away. So what they're doing is they're taking a snapshot in time of these regulations that happened in colonial times when we had these territories that were mostly out west, and were very specific to just preventing terror and fear. Okay, because it was a very lawless space out here in the West. And so, but when the states, when these territories became states, the state constitutions eliminated these regulations that they're relying upon to justify this New York regulation. All right, what else did I want to bring up here? Because and that's really the meat and potatoes. The meat and potatoes is you have a right to carry a firearm in self-defense in public. Keep in mind, the court still has not settled the debate of whether you have a right to conceal carry or open carry or both. Obviously, it's both. I don't understand why my right is somehow negated by a thin piece of fabric that covers it up or doesn't cover it up. And of course, the court says its reference to arms does not apply only to those arms in existence in the 18th century. Obviously, that's something that we know. All right, so let me make sure that. Oh, here's. All right, talked about that. Oh, here we go. Oh, this is another thing. I brought this up in one of my testimonies that I'm glad the court brought up, and it kind of gives me confidence in my choice of going into law, because these are things that I've been arguing since I started Open Carry Texas that now the court is putting into writing. These territorial laws were rarely subject to judicial scrutiny. So even though you had laws like Tombstone and Dodge City that prevented people from carrying guns in there, guess what? Because these were U.S. territories, there weren't people that were suing Dodge City, Tombstone, and this other place. I still can't remember the name of the third city. That they weren't out there suing. And I read it. I read it in here. It's in this brief history, or this long history. But there was no judicial scrutiny of this. It just, no one challenged it. So that doesn't make it constitutional just because there was never any challenge to it. Finally, these territorial restrictions deserve little weight because they were consistent with the transitory nature of territorial government, short-lived, and some were even held unconstitutional shortly after passage. Others did not survive the territory's admission to the Union as a state. The left doesn't want you to know that. They don't want you to know that these laws that but look, they banned guns there. We should be able to do it today. Well, they were also found unconstitutional. All right. And then the last thing I want to bring up here, which I love, is that, when you talk about these laws, the court breaks these laws that have traditionally restricted guns into three types of historical laws. You had what's called common law offenses. A common law offense, you couldn't carry or really do anything that was it Deadwood? Deadwood sounds familiar. I think it was Deadwood. But anyway, these common law offenses were going armed to the terror of the people. If the purpose of you carrying guns, for example, was to intimidate and to get people to, give you free beers and things like that, that was a common law reason that you could not carry guns if they were going to be used to the terror of the people. That's just a common law thing. It's a natural thing. You shouldn't be able, that restricts other people's rights when the sole purpose of you carrying a gun is to terrorize people. And of course, your actions are what determine whether or not you're terrorizing people, not just possession. And then, so the court says there's no evidence indicating that these common law situations impaired the general right of the population to peaceably carry in public. And then the next one was the statutory prohibitions. The court says the antebellum state court decisions upholding them show a consensus view that the states cannot altogether prohibit public carry of arms, but that they could sort of restrict how they're carried. So the statutory prohibitions, even historically looking at them, as New York was trying to, show that even the states understood back then that, well, we can't completely prohibit public carry, but we can prohibit how. And generally, the way they did that was they prohibited concealed carry, because concealed carry was considered back then uncivilized and unmanly, because what do you have to hide? Why are you hiding your gun? Are you going to do something with it? Is there something we should be aware of? That's what it was. And then what's called surety statutes. Now, a surety statute is, so there were some places back in the day that if you were deemed essentially a dangerous person, in order for you to be able to carry a gun, you had to post a surety bond. And by posting a surety bond, which is money, you're essentially guaranteeing, in a sense, okay, I'm not going to violate, I'm not going to use my right and abuse it to the detriment of others. And so these surety statutes, essentially, they didn't prohibit, here's the thing, they didn't prohibit dangerous people from carrying. I mean, if you could afford to pay the fee on the surety bond, if you could afford the surety bond, then you could carry. So even then, trying to compare the licensing scheme to these surety bond schemes or surety statute schemes that they had back in the day, they're not analogous, because New York was preventing everybody. And here's the other thing. You didn't have to post a surety bond until after you were deemed a threat. Here's what the court says about this. Unlike New York's regime, and this is talking about these surety statutes, a showing of special need was required only after an individual was reasonably accused of intending to injure another or breach the peace. Here's my problem with this, but it's also a good thing to say, because that's one of the ways of invalidating it. This sounds eerily like a red flag law. It almost sounds like, so, while we're praising this on one hand, we also need to have our antennas raised and be aware of the fact, because I even underlined this. Not only did I saw it because I wanted to bring this up, I underlined that particular sentence. I want to read this again because I'm afraid this is going to be used possibly to justify red flag laws, and then we're going to have to parse this out. Unlike New York's regime, a showing of special need was required only after an individual was reasonably accused, not convicted, of intending to injure another or breach the peace. That scares me. That line scares me. It automatically gives me due process fears, because reasonably is an imaginary term. A reasonable person doesn't exist. It's this hollow person. It's not average. An average person exists. A reasonable person doesn't. You have to get into the mind of some ghost and say that's a reasonable person. But then it says, even then, so, and this is where I think we can also, so I've scared you into thinking the court is endorsing red flags. But here's where I think we can also overcome that in the very next sentence. Even then, proving special needs simply avoided a fee. So even if you were reasonably accused of intending to injure another or breach the peace, you could still carry as long as you paid the fee. So in some, the historical evidence of antebellum America does demonstrate that the manner of public carry was subject to reasonable regulation, but none of these limitations on the right to bear arms operated to prevent law-abiding citizens with ordinary self-defense needs from carrying arms in public for that purpose. So there you go. And then finally, I will leave you with this. Oh, wait, no, I've already done that. That was my last. Yeah, that's why I underlined that. That was my last point that I wanted to bring up from the case. All right. So good news. Good news. Now, obviously, New York's not going to take this line down. They're going to try to circumvent Heller. They're going to try and circumvent McDonald, and now they're going to try and circumvent Bruen. They're going to find ways, but the bottom line is their show cause, and that includes Hawaii, California, and other places that have show cause statutes in their laws. All right. So if you got a question, put it in the chat room there. I see. Let's see. Where are we at here? Okay. And I think part of the problem, I think one of the ways that while I'm waiting for questions to scroll up here, and I'm not going to give it too much time because I do have to get back to my study, my bar prep. There's a way, especially these days, the loophole that the court may have created here, the left, I can't see them rationally or unironically using this, because even if they use this, oh, look, red flag laws are constitutional. Look, the court says right here, as long as there's a showing that a reason, that a person's reasonably accused that he's intending to injure another or breach the peace, well, by golly, that's all we need. But we'll just make these people pay a fee. I mean, okay, we'll use red flag laws, and we won't completely take away these Second Amendment rights. We'll just make, all right, if you've been reasonably accused of intending to injure another person in breach of the peace under a red flag law, we're allowed to restrict your rights unless you pay $1 million fine or a $100,000 fine or whatever the left comes up with to try and undermine this. Well, that completely destroys their argument about supporting poor people, because now essentially what you're saying is, as long as you can afford to pay the fee, the top 1% of the public is going to be able to circumvent that, even if you go by the letter of what is now the law here. So the left would have to violate their own beliefs in order to support their beliefs. And that's the problem with the left. They can't have a consistent position on anything. Let's see. All right, I'm not seeing any questions. I've given you guys a couple of minutes, so I'm going to go ahead and end this. Yes, I agree. No red flag laws. I don't support. If you're a threat to the public, you shouldn't be public. If they have enough evidence that they can take away your rights, then they have enough evidence to put you in jail where you can't hurt somebody. Due process. That's what it's about. Don't just sit there and tell somebody, oh, we think you're a danger to the public, so you can't have a gun or carry a gun, and then leave that person out in public, where a law or a piece of paper that says you can't have a gun isn't going to stop them from doing anything. Or they'll just go get a car and run over, or they get a knife or whatever. So it's kind of stupid. All right, let me go through here real quick. I do want to talk to you about school carry. I'm waiting. Thank you for waiting until I pass the bar, because I'm making few exceptions. This is one of them. Living in Texas, where I could open carry, I tend to conceal carry in public to keep the normies from panicking. See, I carry the exact opposite reason. I want them to stop panicking. And what's funny is I open carry all the time everywhere. And people don't really panic. People say they're going to panic or it causes panic. But if that were the case, everywhere I went, people would be screaming and running and trying to step over each other, getting out of the building. But I think the only way that you're going to prevent panic is by exposing people to it. And the more it becomes normal and more people open carry, the more people get used to it, well, the less likely it is that morons are going to panic. So I actually carry for the exact opposite reason, but I don't care. Look, I don't care if you carry concealed or openly. That's up to you. Carry however you want. I carry concealed if I'm in a place where I don't have 100% control over who is around me and who's touching me. And therefore, I don't want them to have easy access to be able, if I'm being jostled around in a very crowded place, I don't. Uh-oh, did I lose? I think I lost. I'm being jostled around in a very public place. I'll conceal carry because I don't want someone to easily, if there are a lot of people touching me, I won't know if someone's trying to touch my gun or not. But most of the time I open carry, probably 98% of the time I'm open carrying. Let's see. Why can't we carry in a post office? That's a good question. Are they different than a pharmacy? No. I don't understand why you can't carry in a post office either. For some reason, I don't know. I really don't have an answer because the law says so. But I don't it needs to be challenged. Let's just put it that way. And I haven't looked to see if there are any challenges to the post office carry. All right, so there you go. I'm done. I'm going to end this. Thank you guys so much for tuning into this. It's been 40 minutes. I think that's plenty of time to listen to me bloviate. You can download this opinion. Again, it's the I put the title in the description of the video below. So if you want to look it up, you can also go to SCOTUS blog. I believe scotusblog.org or .com. SCOTUS blog has a link to the text of this, and you can read the whole thing. It's actually a really good. Like I said, I've read all the. I even read the stupid dissents. And if you really want a good if you really want a good laugh and to see the lunacy of the left's view of your rights, really read the dissents. I don't put a lot of weight behind dissents because they mean nothing. There are times where you can use a dissent. For example, when I fought the Ferguson case against Texas DPS, we lost that case only because of a technicality. Essentially, the argument of due process that we were using was not argued at the trial court level. And we tried to argue that because it's a substantive right, that the court should ignore the fact that it wasn't raised at the trial level and still rule that the law that takes someone's license just for an accusation, in other words, an arrest, a class A or B arrest, is unconstitutional because it violates due process. We lost that case because of jurisprudence and res judicata kind of thing, or not res judicata. I'm sorry, I got so many terms going through my head right now. But we lost that case because that's the way the court has ruled on these kinds of things. If the issue is not raised at trial, it can't be raised on appeal. There's a very narrow category. We tried to fit our argument into that narrow category. The court rejected it, but it didn't reject it unanimously, and there was a dissent in that case by the Texas Supreme Court. So, and essentially, in my mind, what that dissent did was give us a roadmap so that when I do become an attorney and I have a client who's been arrested and had their license suspended until the resolution of the case, well, that's unconstitutional. I'll be able to challenge that now because the dissent essentially said, look, this is wrong. We should take this case. This is a due process issue. It's a serious issue. It's a rights issue. And just because it wasn't raised below, it's an ongoing thing and it's legitimate. And then laid out all the reasons why. So next time I have a client who's been falsely arrested because, for pissing off the police, like so the First Amendment auditors that they get arrested and they have their license taken. Then once their license is suspended, now I can argue that at trial so that we can preserve that. And I think we're going to win at the Texas Supreme Court to get that law overturned. So sometimes dissents are good. They provide you a roadmap for how to fight it better. Most dissents, when they're just dicta, it's just, oh, we just disagree, and here's why we disagree. But in our case, the dissent actually sort of gave us a roadmap of what should happen and how we should have argued it and all that kind of stuff at the lower level. So that's just what we're going to do. So anyway, you can go read all of it. Yeah, I'm also not, I don't read a lot of the concurring opinions either. I mean, Kavanaugh had a concurring opinion in here, which is pretty decent. I love Justice Barrett's, Amy Coney Barrett's concurring opinion. Alito's a concurring opinion. I mean, I liked all of these. I don't want to go into each because each concurring opinion was a little bit different, and I think for the right reasons. So each of those concurring opinions, I think, add strength to the case as a whole. They were pretty good. And the dissents were just hilarious to read. All right, guys. It's been 45 minutes now, and I've said absolutely nothing important. So, or at least the last 5 minutes. You guys take care, be safe, be free. I'm going to get back to my bar prep studies. I take the bar. I should be done with the bar July 28th, I believe. So it's 27th and 28th. And then we can really start making some change for patriotism and the Constitution in here. Oh, good. Good to hear, Belinda. Yes, carry always. Carry always. Defend yourself. Be ready. Be prepared. And you guys take care, be safe, and be free. And I'll see you next time something awesome like this happens. Enjoy your right to carry publicly.